The 2013 Constitution is not only legally effective, but also the supreme law of the land from 9 September 2013. Reading down as proposed by the court would mean interpreting the language of the provision section 159 and 160 in a manner that it limits the scope or application, making it consistent with the Constitution or legal principles. In the present proceedings, it is difficult to envisage how the court can seek to limit the scope of application of sections 159 and 160 to align it with the Constitution or legal principles. This is a legal test, Your Lordships. The rule of reading down is only for the limited purpose of making a provision workable and its objective achievable. This is not presently the case, Your Lordship. Those who seek to have the court read down such legislation seeks to import political and or democratic notions as an attempt to weaken the effect of section 159 and 160, and this, of course, would be impermissible constitutionally, given the express provisions of 159 to C. Further, there's no need to read down the relevant provisions of section 159 and 160, as these provisions is not subject to invalidation as being unconstitutional, but rather subject to political maneuvering. The Supreme Court does not have the constitutional power to make any declarations of validity, as this does not meet the court's mandate at section 91.5 and 98.3c of the 2013 Constitution. The amendment provisions at 159 and 160 is clear in its wording, and it's our submission that there's no need to read it down. Now, Your Lordships, Your Leadership, to fully comprehend this, the court will have to delve into the historical development of the jurisprudence of human rights internationally and the role of written constitution in protecting human rights and minority rights. The cornerstone of this jurisprudence is the emergence of the World War II liberal democracies. Now, Your Lordships, Your Lady, from Magna Carta, this has taken almost 800 years to French Revolution, American Revolution, and 2 world wars, to the formation of United Nations in protecting literally the human rights. The jurisprudence and the liberal democracy, the cornerstone of this jurisprudence is the emergence of the World War II liberal democracies, which Fiji is one. Such liberal democracies of which Fiji is one are characterized mainly by the popular sovereignty, underpinning this a system of entrenched laws which protect the human rights and minority rights, in other words, a written constitution. This we submit, Your Lordship, as the true definition of rule of law. It is a journey from rule of man to rule of law. What the state appears to be doing in these proceedings is, we submit respectfully, Your Lordship, is an attack on the rule of law. It seeks to make it easier for them to change the Constitution so that they do not have to abide by the concept of equality in a liberal democracy, so that they do not have to respect human and minority rights if it becomes inconvenient to the majority. This is, we submit respectfully, Your Lordship, is an attempt to revert back to the rule of man. This is an attempt to upend the existing legal order. And there have been certain comments made yesterday during submissions, Your Lordships. That includes the bill that was defeated in the Parliament to make amendments to constitutional provisions, to be resurrected. This we submit, Lordships, as against all norms. You cannot, as per the standing orders and other applicable laws, cannot resurrect a motion that was already defeated by the Parliament. There was another suggestion that was made that since we are a nation in transition, we must have the control of our constitution. We ask, Your Lordship, control in what way? As to tone it down and then have the ability to trample on human rights. These are, we submit appalling statements that can inflict fear and lack of trust on the state, Your Lordships and Your Lady. This will undermine the true intentions of the state, even if they have genuine intentions. We must be very cautious on the messages that we send to the public, not only during these proceedings and outside of it. If they succeed in the new legal order, Lordships, it will be easier for the government to do as it pleases, including allowing the government to trample on the rights of the citizens, especially on the minorities, Your Lordships. The goal is to reduce the Constitution to the level of an ordinary bill of the Parliament, which is simple majority, or at least make it easier to change it. We also note, Your Lordship, Your Ladyship, the definitions that have been used. They are broader and very loose definitions of terms. For example, the definition of popular sovereignty, democracy, representation of the people, and the will of the people. Democracy is not about having an electoral mechanism to elect members into Parliament. Democracy is scalable, Your Lordships, based on the level of protection on the human rights, human dignity, and the independent judicial system. Most importantly, Your Lordship, I do emphasize on that fact that democracy is underpinned by a set of human rights and the protection of those rights. Constitution does not grant those rights to the people. These are God-given rights, we say. Constitution entrenches them so that those rights are protected mainly by the state and the power agencies, Your Lordships. If we are to lower the bar in allowing the state to pass a bill in Parliament and have the ability to trample on those rights, now, there comes another argument, Your Lordships, on the popular sovereignty. And this argument is being the House of Representatives of the people. There comes the argument that the will of the people is represented by the Parliament. This again is a very broad definition, Your Lordships and Your Lady. In outlining this, we must look at the composition of the Parliament today. Very briefly, Your Lordships, the composition of the Parliament, the state, if you look at the numbers, at the time it was formed, it sat at 49.5%. This composition, based on the election results, People's Alliance Party received 168,581 votes. National Federation Party received 41,830 votes. Sodelpa, 24,173 votes. And on the other side, the Fiji First Party has received 200,246 votes, but 42%. The total number that is, would be, if we say, outside of the Parliament, outside of the state, stands at about 49%. Now, this brings the question, Your Lordship, when we talk about the Parliament and whether it is the representative of the people, especially when we are talking about constitutions and rights. Can that representation be taken as the representation of the minority as well? In this case, specifically minority. It sits almost around 50%. If this court provides an opinion that the threshold should be lowered to allow the state to pass a simple bill in Parliament, it is allowing the state to do it as it pleases at any time. Now, on the same context, Your Lordships, we have in this room that who are represented as G blocks. Now, these are the groups, the groupings who were elected or people mandated them as people who have brought in the 2013 Constitution and people who supported the 2013 Constitution. They are now sitting as independent members, Your Lordships. This grouping are volatile in that state as they are standing as independent, and the constitutional restrictions do not restrict them in staying with a particular party or particular mandate. Even this may be a bit outside of this reference and the proceedings of this court, but enough to say that even the Constitution does not recognize the groupings within the Parliament apart from the state and the government and the opposition. Now, if we make a suggestion on the basis the reference was made by the Cabinet, Your Lordships, it appears that the state is arguing that the amendment provisions on its own is creating a constitutional crisis. If we are to take that argument, Your Lordships, what we say here is there's no factual nexus to the constitutional crisis that the state is appearing to argue on. It appears to say that the amendment provisions on its own create such constitutional crisis. Therefore, these questions must be answered. Now, if you take that scenario, we probably could have used this scenario about the G groupings, if it needed, to indicate to the court is one of the examples of having a constitutional crisis. But state hasn't done so. Now, aligning with our submission on the representation of the people in Parliament as representative of the members of the Parliament, even the amicus submits that, I quote, while the notion of popular sovereignty is not contentless, its content is limited. It means that the sovereignty lies with the people, not a particular person or a particular institution. It means that constitutional institutions are servants of the people, not the other way about. But popular sovereignty does not declare that a national constitution must take a particular form or that it have a particular content. Nor is there any international norm that says popular sovereignty must be expressed in a particular way. Nor the popular sovereignty antithetical to constitutional entrenchment provisions, quite the opposite appears to be Fijian and overseas practice, unquote. This is what the Constitution does, Your Lordship. That is to protect the rights, especially, again, I emphasize, on the minorities. This is why we submit respectfully to this court. The state must not be allowed to meddle with the Constitution at their will. Further, Your Lordship, Your Lady, we say, this is why I say this is probably not the forum to address this. This must have a political input. That being having consultations, consensus, especially on the minorities of the minority. Their views must be taken, and they are not necessarily represented by the Parliament. Now, as in the yesterday's proceedings, His Lordship Justice Mataitonga also raised a point where this issue may have been taken in the original jurisdiction of the High Court, possibly. Now, we submit the way it could have been done. The state has not done so, but the way it could have been done, the state could have identified certain rights that have been violated and relate those violations of rights to the provisions in the Constitution. Because of these provisions in the Constitution, these rights have been violated. Therefore, Constitution must be amended. But we cannot amend the Constitution because of the amendment provisions. That would have been the discourse if we have approached this issue in that way. The state hasn't done so. Thus proving our argument to some extent, Your Lordship, that the court must not enable the state to make any amendments. Going further, Your Lordship, there was a suggestion also made. There were few statements made again on the referendums, Your Lordship. It is costly. It is difficult to achieve. And these are all, in fact, if you look at the reference where there's no factual nexus, most of these arguments are hypothetical, no factual basis. Now, there was a suggestion made yesterday, just to illustrate our argument further, on the referendum. Now, this proposition is that the registration of voters, the act, be repealed and replaced with the provision of fresh registration of all the voters. Electoral Registration Voters Act 2021. As the venue for the referendum, we can have those who are coming to re-register at the same venue, if need be, to have the referendum. This way, we can also achieve 100% of the registered voters. Now, to one of the most important aspects on the questions raised yesterday regarding the reasons from 2/3 to 3/4. 2/3 was in the 1997 Constitution, Your Lordship. And even in the 2013 Constitution, when the explanatory notes were talking about 2/3, how and why did it increase to 3/4? We submit, Your Lordship, in 1997 Constitution, it had the communal representation. There were entrenched provisions in that Constitution, Your Lordship, where it was designed, by design it was done that way. Majority, including the minority groups, are represented in Parliament. There were specific ethnic seats, Indians and Fijians and the mix. This was done deliberately at the time to ensure as much as possible the groups, different groups are represented in the Parliament. It went further than that, Your Lordship. Section 51 and 52 of 1997 Constitution entrenched that. Further, there was power sharing. Section 99 says the Prime Minister must invite anyone with 10% of the total membership of the House to be part of Cabinet. These were the reasons why 2/3 requirement was in 1997 Constitution. In 2013, the scenario is different, Your Lordship. It is one man, one vote, national constituency. It does not have that protection or that ability to ensure all the segments, all the minority groups, to a large extent, can be represented in the Parliament. This is where we say the 3/4 of the referendum was required. This, Your Lordship, brings our first segment to conclusion. Unless there are any other questions from Your Lordships, my colleague, Mr. Nandan, will take the court through the second segment.
My lords, my lady, Mr. Karunaratne has covered what I would consider to be the most important aspects of our submissions. I will just try at this point to build on his submissions. In particular, the central theme of his submission is best encapsulated by the saying that eternal vigilance is the price of liberty. And that saying is most apt in these proceedings. Regarding specific questions that were put to the court in the referral, the first question, is everybody has noted prior to me, contains two aspects to it. The question one itself, the first part asks, are provisions of Chapter 11 and of Part D of Chapter 12 of the Constitution of the Republic of Fiji binding on the people of Fiji, the Parliament of Fiji, and the Supreme Court? If that question stopped there, then the answer would be yes, it is binding. However, then the question continues to add these words, with the effect that none of those provisions can ever be amended, regardless of the will of the Parliament or of people voting in a referendum. Now, we say this part seems incongruent with the first part of the question itself. And also, the court does not need to accept this part as an established fact. In fact, what that second part represents is what we term as logical fallacy. It basically works like this: because I have never seen a black swan, no black swans exist. So because amendments have never been done historically in Fiji, they can never be done.
But look, just pause there.
Yes.
Is it really conceivable that an amendment would receive a support of a 75% majority of all voters in a referendum? Are you saying that that is a practicality?
I am saying, my Lord, there is no possible way for us to be able to answer that question either way.
Why can't we just answer it on the basis of the common sense we apply in relation to everyday decisions in life?
No, my Lord, because this is not on all fours with anything else that we will do in life, in common, in our life.
So what you're saying is, because it's a really difficult question, we should just proceed on the basis that it is possible. Aren't you just effectively not engaging with the issue by doing that?
Now, my point is that...
So you say, how do we know it's not possible, but you are not really prepared to engage with the issue? How do we know it is possible?
I am prepared to engage, my Lord, of how do we know it is possible. And the way you do it is you try and pass the legislation through the Parliament, and then you try and do a referendum and see what the results of it are. There has only been one attempt at that so far. Let the state do the work first and then test whether the results of that work is constitutional and lawful or not. So they have put the cart before the horse and come here to this court. That is what I'm saying.
You say we should suck it and see.
Sorry, my Lord.
So we shouldn't speculate as to what might happen if there was a referendum until a referendum has been tried.
That is correct, my Lord.
Mr. Nandan, just one question.
Yes.
In the history of elections in this country, when it was not compulsory people going to vote, it has never got anywhere near that number. How do you think it will magically change simply because it's a constitutional referendum? Where does that extra wisdom come from?
Where do we, how do we extrapolate?
We have had elections.
Yes.
And even in those elections, at best, it's never gone as far as 75%.
Yes. So.
And then they took out the compulsory election, that people have to vote, compulsory voting, which is one way of making sure that people will also. Now we are in what I call Lululand.
Yes. So the amicus in his submissions interprets the referendum part of the double supermajority requirement as such that of all the people voting in the referendum, it needs to achieve 75% of all the people that have voted. So there is a distinction, my lord.
There is,
yes,
of course.
Yes. You don't have, what he's saying is you don't have to achieve 75% of the registered voters voting in it, but rather the results of the voting has to be the 75% of the voters who voted in the referendum.
Well, that's the interpretation. It's not what it says. All previous three supermajorities, which were in relation to Parliament, were said to have a denominator of all members. So there is practice that suggests that that it is a majority by reference to all who could vote. And then secondly, reading it down presupposes that the framers of the Constitution intended this provision to be capable of practical application. If they had, it might have been a good idea to pass legislation providing for a referendum.
Yes, my lord. But that is still possible, but the Parliament can still pass a legislation providing for rules of how a referendum is to be carried out. That provision is there within the Constitution. It's just that nobody has acted on it. And again, this comes back to the state doing its work first before coming to the court.
When Mr. Karunaratne was on his feet, I was following a lot of things he was saying. And I was resisting interjecting on the basis that you might end up in the confused state that Lord Diplock said in one of his ruling on Madison book, that you are going to engage yourself in tabulated legalism. Aren't you now in that quagmire?
No, my lord. I believe that our position is fairly clear. We are advocating on side of, if I may say so, constitutionalism and also liberal democracy. There is two parts to, when we talk about democracy and when we talk about democracy in this court, what do we actually mean? The two main characteristics of a liberal democracy is the popular sovereignty bit, that's the manner of electing our representatives. And the other bit is what Mr. Karunaratne was talking about, the entrenchment of human rights and minority rights and the basic rights of people. Of the two features, I would submit very strongly that the second feature is actually the more stronger one, the liberal part of the liberal democracy. Liberal democracy. Now, what the state is asking you to do is reduce the threshold requirements that allows it to change the Constitution. And therefore, by implication, it is also weakening the protections of those entrenched rights. And once you open that Pandora's box, can you really put it back in? Are we not now then providing a pathway to unraveling of all the rights in the Constitution itself?
The problem is that it's a very powerful submission on its own.
Yes.
As regards the 213 Constitution, it's internally confused. Why? If you look at Chapter 2, which provide all those very interesting rights, which I support, but then halfway down through all those provisions, there's an internal contradiction. Even if we don't nothing else but just pass an amendment to make that more stronger, yes, I'll be in support of it. But the problem is you people use arguments that are very good at the front end, but at the end of the schematics, it's actually confused. If you look at all those provisions, and that's the first time,
yes,
it has been stipulated that way in any of Fiji's previous constitution, and it's good coming in with grant rights. The one thing that Mr. Ravi, this is my favorite, they didn't put any specific rights for women, which really disturbed me. The important thing that I see, you give all these rights, both the political rights and also the socio-economic rights, but then you never provided for it.
Yes.
So, don't try and rely on the first half and then forget the other half as a way of arguing a political argument, because
Yes.
it won't support the argument.
Yes. I am not saying that this constitution is perfect. In fact, I have my own issues with the its constitution, particularly the constitutional, the provisions which relate to the constitutional review of violation of rights under this constitution, which seems to be highly prescriptive, and to the point where I almost feel like you might as well not have those
That's
rights
right.
there. You have those rights there. However, nonetheless, despite that extreme prescription, there is a pathway to challenge violations of human rights, etc. in there. You just have to be in time within 3 months. I think most legal practitioners have a problem with those provisions, but the only way we can actually address that is follow the amendment provisions of the Constitution, and hopefully we'll have enough support within the Parliament one day, and perhaps, and I believe that the public will vote in its own right and will achieve that 75% to change those things and make those protections firmer. But over here, we are asking that the provisions which allow the amendment to the Constitution, that in itself be weakened so that that gives a greater ability to the state itself to amend the Constitution. Now, that's where we have to be cautious. That's where the saying that I had previously referred to, the eternal vigilance is the price we pay for liberty, comes into effect. You start that pathway, then we keep going down it to the point where I would say, I mean, the starting point, the default position of this court, where the state is coming to this court and seeking to increase its own powers, ought to be to treat the state as the villain of this piece. Treat its motives as malefides, treat it with caution. And that ought to be the default position of this court when looking at this reference in its entirety.
In a constitutional sense, we are not talking about the powers of the state. We are talking about the powers of the Parliament, are we not?
Yes, but in a constitutional sense, that is correct, my lord. But in a practical sense, that if there is a majority in the Parliament, if the government of the day holds that majority, then you have to be aware of the dangers of going down that path. That is the point, that is the central point the FLP is making to this court. My lords, I could very quickly cover the other questions that have been referred to the court, but I think we've had a more interesting discussion outside actual reference to the questions itself. The question 2 says, may the provisions referred to in question 1 be amended following enactment of Bill of Parliament to do so in terms thought fit by the Parliament? And the answer we respectively submit is no. And again, this question, all the dangers that we've been talking about is inherent in that question. In terms fit for the Parliament, what does that mean? Are we going to give unbridled power to the Parliament and the state here? Is that where we are headed? The question 3 says, is approval of any amendment proposed in accordance with question 2 effective only if approved by the people of Fiji at a referendum? I have some difficulty understanding what that question is asking for in the way it is phrased. The best I can offer is that the answer is yes, because it is a requirement under the Constitution that a referendum be held. And question 4 is any special majority, and if so, in what proportion necessary for enactment under 2 or approval by referendum under 3? My lord, again, our position is that we have to follow what the prescription in the Constitution is. However, this question puts the state and parties that support its position in an interesting position before the court. It ends up bargaining with the court is if we reduce the threshold requirements, what it should be. And it just becomes some sort of a bargain. And I would submit that the court should not engage in that sort of negotiation with the state.
No, it's not a bargain. When I raised this issue yesterday, I'm going to raise it again, and I want you to answer this.
Yes.
When I was pushing for two-thirds, it was because up until this one, it has always been two-thirds. It's based on some history. So I'm asking you this morning, how did we go to three-quarters?
Yes.
You'll not be able to answer that question unless you are part of the group that signed it in. Because it's a question that is still not being answered and cannot be answered factually by someone who is willing to take an oath.
Yes. But, my lord, I can attempt to submit on the reasons why the three-quarter threshold is more desirable under
Not on what I predicated what I asked on a history.
Yes.
And for those that were making a big issue about the double entrenchment, that double entrenchment in the previous constitution were limited for precisely what Mr. Karunaratne correctly referred to protect certain particular interests, which are important interests. I'm not trying to denigrate or take that away.
Yes.
But I was looking for some basis on which it jumped from two-thirds to three-quarters so that it can be justified under 2013. There's none. In fact, the report that they last looked at before they wrote whatever they wrote said the opposite.
Yes, the notes we found had said it cannot be denied. It said two-thirds for both the parliamentary majority as well as the referendum requirement as well.
They didn't want the referendum.
Yes. It's just a historical fact that this is the first time we've had a threshold set higher than two-thirds in the parliament.
That's not quite right, is it? Weren't there some provisions in the earlier constitutions that could only be...
1990.
Sorry, no, was it
1990 constitution, yes. But like we had yesterday, the saving grace of that constitution was it was a transitional constitution which was there for only, and within 7 years of its enactment, it had to be changed. And thereby, the 1997 constitution came about. And believe you, my lord, there was, at the time of the abrogation of the 1997 constitution, there was nobody who felt more offended than myself that could be done in the manner that it was done. However, as this we've had, and this court has pointed out to the interveners yesterday, we've had 3 elections under the 2013 constitution. And especially those interveners who are advocating for the validity and existence of 1997 constitution, I fully agree with what Justice Matai Tonga was hinting at yesterday, that is a matter of trial before perhaps the High Court in some manner. We will need to have evidence before the court. Facts would have to be established after that evidence has been tested by a trial, and those facts then have to, the principles of doctrine of necessity and doctrine of acquiescence would have to be applied to those facts to see which of the constitutions persist or exist. Now, it is not an undertaking that this court is able to effectively take. And that would be my answer to the fifth question that has been referred to the court. There is also this other issue that I wish to raise with the court.
You're going to run out of time very soon.
Yes, it's just a jurisdictional issue. This court derives its jurisdiction from the 2013 constitution. There is law here that the court cannot rule or pronounce or declare, or that make declarations which will unmake the constitution which gives its jurisdiction. And that seems to prohibit this court from effectively dealing with the 5th question.
Only if we say that our opinion is for that you abrogate the 2013.
Yes, my lord.
Yeah, so limit purchase is what you mean.
Yes. As I am about to run out of time,
I think
is